Good morning. Sir, help me pronounce your name.
Tasso Malone.
Malone. Are you ready to proceed, sir?
I am your honor.
All right, you may proceed. Would you like to reserve some time for the public?
Yes, 5 minutes.
You have it.
Your honors. I'm Tasso Malone, the plaintiff in this matter, and I was with the appellant in this case. The case arises, this appeal arises in the context of a larger case that involves multiple defendants. And I think it's important to understand the background. There's essentially three layers of defendants. The primary defendants are my sister, Helen and Jenny, and they are the putative trustees of my deceased mother's trust. The secondary defendants are the Wells Fargo defendants, which are collectively the Wells Fargo advisors, as well as two of the individual brokers who handled my mother's affairs subsequent to the father, one of them who had handled previously. The tertiary third level of defendants are basically included only to comply with the requirements of Chapter 736 of Trust Code, those are interested parties, any action that may affect the interest of a trust beneficiary. The trust beneficiary needs to be named as a defendant. There's no wrongdoing was alleged by the part of the tertiary defendants. There were and are unresolved issues regarding the primary defendants. That's important because those issues are interdependent to the matter at hand. One of the principal issue is whether the trust that was executed, whether an amendment that was executed to a trust was either properly executed or whether it was procured by undue influence by my sister Helen.
You might be talking yourself into a motion to dismiss this appeal, the 9.110K. They're so interdependent that this is an unappealable order.
But it's appealable, and it's appealable because the issues regarding the Wells Fargo defendants release them from this litigation entirely.
Okay,
So
so you got to dismiss the defendant. Now, they're obviously arguing that the cause of action against their client is completely independent under a different theory of liability fiduciary duties.
That's correct, and their theory goes to the heart of the interdependent issue.
But you've got to really convince us how the unresolved issue of undue influence against your sisters, whether that's true or not, I hope not, family matters with that, but how the resolution of that case controls the resolution of this one when it's a banking entity that has different liability to customers and trustees.
The issue is exactly that: a bank, a financial institution, owes a duty to its customers. That begs the question:
How did you become a customer?
That issue remains unresolved, and that is the problem. That is the issue. Under Florida law, under trust and estate law generally, an individual who's a trustee of a revocable trust would be the customer. I don't think the appellees would argue that. When an individual, the grantor of a trust, dies and the revocable trust becomes irrevocable, and for the first time becomes irrevocable, the trust duties need to be carried out by the successor trustees, much like corporate directors carry out the duties of a corporation. There's no McDonald's, but there's directors, is all right, carry out the directives of the institution. The successor trustees under the one version, the pre-amended, if you will, trust.
I don't mean to interrupt, I really don't, but you have 20 minutes, it's not very long.
I understand.
In this particular case, sir, a motion for summary judgment was filed. You missed your 20-day deadline. Mr. Shrill's even out of a professional courtesy said you missed it. You were in Greece. Greece has Wi-Fi. You were in Greece, you told them you had COVID. The judge continued, you still missed your 20 days. The judge told you, I'm continuing it out of courtesy for your health and everything else. But you missed your 20 days. You didn't file anything at all as to the motion for summary judgment, did you?
I did.
No, first one. Did you file anything other than an emergency continuance?
I filed the emergency continuance.
That's it.
That is,
That's not evidence. Okay, so when you get to the hearing, you don't have any evidence, do you? You have nothing under oath, no affidavit, no depo, no interrogatory answers, no answers to request for admissions, nothing. Is that true?
that is correct.
Okay, you, to your credit, are a banking lawyer. You know banking,
I'm not a bank.
but we can't consider,
I'm not a bank.
we can't consider your knowledge and experience in probate law, banking law, fiduciary duties, and all that kind of stuff. That's not evidence. So what evidence did you have of record that's admissible in opposition to their motion for summary judgment?
And procedurally, the issue was when the motion was granted to continue the hearing, it did not set forth a date for the continuance. And there was no way to count the 20 days from then. It was just,
Are you saying the continuance is like extends your deadline?
I believe so.
Well, the first DCA totally disagrees. It's right hot off the press from State Farm versus Advanced X-ray. Let's see, there's a Westlaw letter somewhere around here. Can't find it. Trust me. But I don't see where the rule, if you miss the 20 days and then you get a continuance, where the time clock starts again.
Because 1.510 says 20 days before time fixed for the hearing.
Right, you had a first hearing.
And the continuance was granted, and it was implicit.
Your continuance was granted because you had COVID. You didn't say anything else. You didn't file anything else. Even though Greece has Wi-Fi. I know. You didn't file anything. Where does the rule say that 20 days gets extended if the hearing is continued? Where does it say?
I believe the Supreme Court decision of Titusville Associates versus Barnett Bank says that, which is second to that.
Okay,
It says, in addressing the issue of timely notice, the court stated, had Titusville Associates required further time to oppose the motion, it could have sought a continuance pursuant to 1.510.
yeah, but you didn't seek a continuance for any other reason than your health. You did not say to Mr. Shrills, I have a legal objection. Here's a depo transcript. Here's a memorandum of law. You simply said, sir, can you please continue because I just got COVID, right?
I didn't just get it.
Well, sorry, but glad you recovered. But
Doesn't matter.
that's what it was all about.
To the summary judgment standard issue, there still has to be, and the court can look at those facts, there still has to be no dispute of material facts. Here there is a disputed material fact. Who is the trustee, which goes to the heart of the customer issue. If in fact the documents were procured by undue influence and or improper execution, one, if not both of those individuals would not have been the trustee. It would relate back to day one. And so by saying, well, there's no way that there would have been a different trustee because we've got our self-serving banking documents. No, the trustee goes to day one.
Wells Fargo has this trustee certification of investment powers, which requires it to be filled out, signed under oath before a notary, subject to perjury. Your mother signed it and your sister signed it, and it was sent to Wells Fargo. Are you arguing to support that a banking entity that handles trusts must go beyond that to determine what the intent of these people is or are when they fill out a trustee certification of investment?
I'm arguing that it's self-serving. I'm arguing if
How does it-
I procured that document by undue influence,
But
that would not be valid.
scream out to Wells Fargo, undoing.
It doesn't, that's only. to
Okay,
Wells Fargo.
well, so my point is, if you didn't file anything in opposition to all of the documentation that they filed, listed, copied you with, and gave you plenty of time to respond to.
Well, can I just interrupt one question? Is your basic argument say it doesn't matter if I didn't file countervailing affidavit or countervailing evidence because they have a failure of proof? The burden of proof wasn't carried regardless? And if so, how do we know that?
I think we don't know that. I think it's unknowable unless and until trial court is able to adjudicate whether in fact the documents we were purportedly operating under are in fact the correct documents, that they were properly executed and they were not procured to undo influence. Right now, there's the finding.
You know, I kind of get that, but this happens all the time in summary judgment. They file documents that they're unrebutted, the trial court can take it as face value. And you're saying they can't, they have to take another step, as if you had filed an objection saying there's no proof what they indicate in the documents is correct.
I'm saying 5.10 allows the court to look beyond the record.
Okay.
To independently look at the record.
But they're not required to, they might allow them, but they're not legally required.
That is correct.
Okay, that's what I'm trying to figure out what your argument is, I understand now.
That is correct. And the other argument is that it was implicit, at least Steve implicit on my part, apparently not, pursuant to Judge Sleep, implicit that the extension of the hearing date would extend the response date. Because if it didn't, just pragmatically, why have another hearing date? We're wasting everybody's time. And in fact, we would have been in a default mode. If we said, we're going to extend it another week or a month or 6 months, but it's essentially a motion to eliminate, because when you get there, you can't bring witnesses and you can't bring any
Well, I
evidence.
can't
You're not gonna be
imagine,
able to bring testimony. So why have a hearing?
I can't imagine the argument you would be making had he not granted you that continuance and granted a summary judgment motion when you filed your emergency motion. You'd be saying the same thing. You didn't file anything in response. The rule doesn't extend the time. If the rule extended the time, there'd be a proliferation of litigation. You would be getting new evidence all the time. Everyone would be objecting and the courts would be clogged. There needs to be a deadline.
I respectfully disagree, Your Honor. Not all hearings are continued. This one was, and the 5.10
The deadline,
says
the
28
filing deadline,
years.
Yeah,
the filing deadline had already come and gone at the time you moved for the continuance.
And
The filing deadline was July the 19th, 22. Nothing was filed, and on August the 5th, 22, there was a motion to continue.
Correct.
So the lateness of the filing, or the non-existence of the filing, was already cast in stone before the continuance was requested.
well, again, the lateness was largely due in part to my illness.
But the judge told you at that hearing that your time has expired to respond. You filed no legal challenge to that ruling by the judge. I don't want you to sit here and think I've prejudged this case and I'm telling you what is and what isn't evidence. I'm just looking at this record, this cold record shows that you didn't file anything in response during your 20 days. And when the judge told you, when he granted you the continuance, your time has expired. You didn't challenge that at all.
And I think that it was being challenged. I think that's inconsistent with granting victims under Titus. Because when we're going to extend it, they didn't say we're going to extend it to the next date. He said we're going to extend it to whenever it can be scheduled with the court. Now, if you called the next day and said we're having a hearing tomorrow, obviously there wouldn't have been 20 days. We would have been unknown. We didn't say we're extending it a month or 6 weeks. He just said we're extending it. And then 3 days later, like, oh, here's kind of essentially a day.
All right, so you're almost at 15 minutes, sir. You can use your time the way you want.
So, thank you.
Watch, you'll have 5 minutes.
being made of this court. These proceedings, we all want to together with Fred Shrills. We represent the athletes, Mason Aaron, George Felios, and Wells Fargo advisors. This court's already indicated. This issue is what claims were brought against the Wells Fargo defendants. They were not trust claims, they were claims for breach of fiduciary duty, professional negligence, and vicarious liability. Each of those claims requires that the appellant prove that there was a duty owed by the Wells Fargo defendants towards him based upon the trust account, the investment account held by the trust of Wells Fargo advisors. But he's failed to identify any duty whatsoever. He's failed to identify any law, rule, regulation, or contractual provision that would give rise to a duty to him for Wells Fargo advisors' actions with respect to the account, the investment account. He has maintained that it's somehow interrelated with the claims against his sisters, but he has not brought claims based upon probate or trust law. He's brought claims, basically negligence claims, in which you have to show some duty. And essentially, Wells Fargo advisors has nothing to do with the trust. There was money, the trust came to Wells Fargo advisors, they opened up a non-discretionary brokerage account, and they executed a trust certification. And that trust certification that was executed in 2017, sometime in August, basically sets forth some of the requirements, some of the duties that Wells Fargo would owe the client. And the client here is the trust. And the trust certification states that Lula Malonis is the sole trustee, and during her lifetime, she is the one who gave instructions, and it names Helen and Jenny as her successors. And upon her death, the successor trustees became those persons who were authorized on the account to basically direct what would happen with that account. And basically what he's asking us to do with this, some sort of retroactive application of a duty that might arise sometime in the future if it is determined that Helen is not the rightful successor co-trustee, and if he is, which basically would require us to go back in our time machine, back to the time when these things happened. He's basically asking the court to impose a rule that would require Wells Fargo advisors to act in contravention of a certification of trust executed under penalty of perjury that says you are to take direction from me, the sole trustee, and upon my death or incapacity, the successor co-trustees. That is an unworkable standard and is not one that is recognized in any law. We act based upon the laws, rules, regulations, and contractual provisions that bind us at the time of the actions that we take. They did that based upon the trust certification. He has pointed to no other source of duty to him. If he wanted Wells Fargo essentially to stop acting pursuant to the certification, he could have gone to the court in this case. He could have asked for a temporary injunction to basically freeze, what was happening, but he didn't do that. So having failed to do it, Wells Fargo advisors, they had their instructions. Their instructions were in a document executed under penalty of perjury, and that's how they acted. They owed him no duty. He was not an owner of the account. The account owner was the trust. He was not an authorized party in the account. Those were listed in the trust certification, and he was not listed there. Now, we believe that, Wells Fargo was entitled to summary judgment based upon the merits. However, the court did not err in striking that response. As this court's already noted, it was long overdue by the time he requested the continuance. And I would note, if you look at that motion to continue, it's not a motion to continue the extension of the deadline to actually respond to the summary judgment motion. It's just a continuance of the hearing based upon illness. And that, we're not going to contest that the court could do that, but there was actually attached, and it's in the record, but basically there was an objection by Mr. Shrills. It basically said, look, your deadline is passed. we object because, that deadline is passed. And when the court, both at the hearing, the court said, okay, I'm going to extend because of your illness, I'm going to extend or continue the hearing. And he also, in his written ruling, specifically says that this continuance in no way extends any previously expired deadlines or otherwise alters any requirements related to the Wells Fargo defendant's motion for summary judgment, including the deadlines and requirements for opposing a summary judgment. Because at that point, it was long past. It was done. Now, I do want to point out just a few things with the certification. That is what governs Wells Fargo actions, as well as Mr. Merriman and Mr. Valios. There is an allegation, there's an allegation that there was a trust certification. He attaches the trust certification to his verified and amended complaints. No allegation whatsoever that it was procured by fraud. No evidence that it was procured by fraud. What he wants to say is that, well, in the future, my sisters are determined not to be the rightful successor co-trustees. That relates back, and Wells Fargo never had authority to basically act upon their instructions. That is simply untenable. He has proven there is no duty, and each of his claims against Wells Fargo advisors require that he prove a duty. There's no duty existing under law, rule, regulation, or contract. So because he cannot prove a duty, and that is one of the elements that he, as the party who would actually bear the burden of proof at trial, because we pointed to the absence of duty, even in his untimely and non-compliant response to the motion for summary judgment, he did not present any evidence whatsoever establishing a duty, nor did he present any evidence whatsoever establishing that certification was somehow procured by fraud or somehow unlawful. He proved that he could not prove any duty, and for that reason, the summary judgment should be affirmed, in addition to the fact that the trial court did not err in striking his untimely and non-compliant response.
Okay, so you may be arguing harmless error. Huh? So if the judge may have erred in striking his ability to reply in opposition, that once they had the hearing, the court did consider. As I can see from this transcript, Mr. Maloney did testify, but it borderline about his experience in banking, best practices in banking, this, that, and the other things should not have been done. Even if that were an error, it was harmless because the court did consider everything that it needed to in the record and should be affirmed.
That is correct, although I would just point out, it's an abuse of discretion standard. And so I don't think that the court abuses discretion.
Summary judgment. Striking is abuse of discretion. Yeah.
Striking is a, right.
Summary judgment, no.
Correct. Summary judgment is no. But again, he bore the burden of proof because that's an element of his claim. We pointed to the absence of it. In response, no evidence whatsoever, no law establishing that there was a duty owed. And for those reasons, we think the summary judgment should be affirmed, and we would ask this court to do so.
Thank you.
Thank you.
You have your 5 minutes. So.
Respectfully, it seems like we're agreeing, but coming out on different sides of the agreement. I agree that the trust is the client. The trust is the client. Trust as an entity, once the decedent has passed, when the decedent's alive, they carry out the duty. Those functions are carried out through the trustees. If in fact there was perjury, if in fact the document.
Can I back up just a second? Because you agree that while your mother was alive.
Say that again.
You will agree.
Yeah, absolutely.
While your mother
absolutely
was alive, she had the sole right to designate who would be the trustees.
That is
And
correct.
she did that by way of this trust certification before her death, correct?
You don't want to hear my.
I know. I
Statement, so.
know that you.
It's exercised through the execution of a proper trust or trust amendment. That is what's being challenged. That is the source document. Just like they say, these assets aren't trust, they're assets of the trust. The trust is the shell. Everything is living within the shell. All these powers are coming out of this bucket. If the bucket is broken, if the bucket is improper, if there was fraud, perjury, undue influence, whatever, then that contaminates everything else. That is the point. I agree that the trust is the client. They can see that the trust is the client. And once my mother, as sole trustee during her lifetime, died, then the successor trustees essentially become the client. The challenge is that information is unknown and unknowable. If you look at 510, it talks about facts that are unknown to the movement, to the non-movement. It is still, this thing has not even been set for trial yet. Right now, today, I can't tell you whether that trust is going to be set aside or not. If it's not, then have at it, great, then no issue. But if it is set aside, just in the notions of fairness, just kind of step beside some of the procedural stuff, just in the notion of fairness, if it turns out, oh my God, she did perjure herself. My mother was mistaken. That document was a product of undue influence. All the trust certification document does is pardon my French, cover Wells Fargo's butts. It doesn't mean it's right. It doesn't mean that should have been accepted. I'm not saying they have an affirmative obligation to go out and you know, do lie detector tests, but I am saying if it turns out that that document was fraudulent, it throws the whole thing into question. And I'm just saying out of notions of fairness, both procedurally and legally, it would seem to be appropriate to have that seminal issue, who the trustee is or are the proper parties that will be carrying out the duties of the trust and go forth from there. If it turns out that the trust, as we believe, and as the court is inclined to, that trust was the product, the trust amendment specifically, is a product of undue influence, to the extent Wells Fargo's out of pocket, they can go after that trustee. That could trustee for having lied. And it's almost like saying, well, this person lied, swore their oath, but you know, liars swear all the time, committed perjury, fraudulently obtained a document, did all these other bad things. But Wells Fargo protected because, you know, we got the name on the bottom line. No, if that person did all those bad things, Wells Fargo ought to come after them. As far as what other trustees do, that's the reality. When that account was moved, these same issues were raised to Chase, which is all large, I don't know, large or small, but a reputable financial institution. You know what they did? They shut it down. Those funds were frozen from day one, where they remain frozen. So this is my best practices or what should happen. This happens all the time. Happens in real estate deals, happens in banking deals, happens in broker deals. When a question is raised, it says, well, you know, you should have gotten an injunction. There's emails that say freeze that account. No, it wasn't a court order, but they were put on notice. These are outstanding issues. You guys need to be concerned before you let the money go. And they did. Thank you.
Thank you very much. Wish you all a good day. We're adjourned.
All rise.
Oh, yeah, that was fun.
Thank you. Travel safely.
All right, thank you.